BANKcr1 is now in session.
Thank you. You may be seated. We are here today on our case number 1CACV160515, ANTSELIOVICH versus US Bank. Counsel, as you know, each side's allotted 20 minutes for your argument. The appellant may reserve any amount of time you'd like to use in rebuttal. If you do decide to reserve time, though, you're in charge of keeping track of it for yourself, because the clock on the podium will reflect the total amount you have remaining, including what you might have decided to reserve. We record these proceedings, so we'd be grateful to you if you would give us your name and the name of your client when you approach the microphone. We've studied the briefs and the second amended complaint, and we've also discussed the case in our conference. So with that, Mr. Silverman, you proceed.
Good morning. May it please the court, my name is Stephen Silverman. My clients are Paul ANTSELIOVICH and Oksana Gulis, his wife. And my intention is to try to reserve about 7 minutes for rebuttal. Might end up being less than that if I get a little bit too
That's how it
wordy.
works generally.
Essentially, there were 4 errors in the trial court proceedings below. The first was the failure to apply ARS 47-3110D. A check is only deemed to be endorsed if all of the parties have endorsed the check. In other words, that until on a multiple payee check under 3110, unless every party has signed the check, it's not deemed to be endorsed. The person that endorsed the check is all of the payees, and that's the set forth in a comment in the UCC as well as the other cases. The second error was the conclusion that my clients transferred the check to the contractor. ARS 47-3203A indicates that a transfer occurs only when the party receiving the check has the right to enforce it. Because the contractor did not have the right to enforce the checks when he received it, it's not deemed to be a transfer under the statutes. The third error of law, was the conclusion that a breach of contract is a necessary prerequisite for a claim that a party has breached the covenant of good faith and fair dealing.
Let's finish talking about the claim against Chase and Wells first.
Oh, sure. I was just going an overview of what I was going to be covering, but I'm happy to talk more about that.
Okay. What is your client's theory about what would have happened? Say U.S. Bank had endorsed the check, so there's no conversion claim then, because each of the co-payees would have endorsed it. And then the money would have gone to the contractor, presumably, and your clients would be in the same position, no?
Well, no, because that's not the way that these transactions work. The mortgage insurance clause is standard, and the practice for how these checks are dealt with is standard, and that is the checks are ultimately deposited in the account of the mortgage company. So in the event that had something unusual happened and U.S. Bank had provided its endorsement on the check, then it would be a different case. But I don't think that ever happens. What is supposed to happen is the checks end up held in an account that's for the benefit of for the borrower. Money is to be applied either to the repair or to the principal indebtedness.
So who writes the check to the contractor?
Ultimately, I guess it could be either the mortgage company out of the out of the escrow account. More typically, it would be the borrower would write the check. They'd receive the money and then write a check for the.
I think that's the typical way. It's not that this particular check would have just been turned over with US Bank signature and then deposited by the contractor.
No, and in fact, the contractor had not done any work, and so so at the time that the checks were endorsed, these were a series of the first three were undisputed funds payments on the part of the insurance company while the claim was being in the protracted adjustment process, and the error wasn't discovered because the claim was in the appraisal process, and insurance appraisal is a form of ADR-like arbitration, but a little bit less formal. So at any point in time, the contractor, while this case was ongoing, did not have a right to those funds. Had he done the work, then he would have. But at the time that he converted the funds, he had not. He basically just walked away with the money.
So the theory would be that if that after U.S. Bank endorsed the check, rather than give the check to the contractor, it would have negotiated the check and held the funds in the mortgage escrow account and paid out to the contractor as the work was completed, as it had the right to do under the deed of trust.
Sure. Yeah, that would have been that's what's supposed to happen, and that's their program is standard. U.S. Bank's.
But I don't see U.S. Bank saying it would have done that. Matter of fact, U.S. Bank is disclaiming any obligation to do that under the deed of trust.
Well, the mistake that in the position taken by U.S. Bank is the assertion that the plaintiffs did not have any rights to the checks at all. And we cite a couple of cases that are referenced at page 92 of the appendix. We rely principally on the Gillis decision out of Michigan, which makes it clear that the funds are the property of both. So the money, even if the money is paid to U.S. Bank has contractual obligations to do one of two things with the money. Either it goes toward the cost of repair, or it goes to reduce the indebtedness of the mortgage. And that
I find that contractual obligation.
That's in the mortgage insurance clause. It's cited you can find it easily in the appendix at page 5 of the appendix. The trial court set forth the mortgage insurance clause.
But if US Bank says all we would have done is sign the check and we would have released it to the contractor, isn't your remedy against U.S. Bank and the contractor as opposed to Chase Bank?
Well, as it relates to the conversion claim against Chase and Wells Fargo, the ultimate purpose of the UCC is to impose liability upon a bank that violates the practices that in a situation where there's a lot of these situations there's a thief who's run away with the money.
But is there any damage whatsoever if U.S. Bank says, yeah, we would have, if that had been given to us, we would have signed it and it could have been deposited by the contractor?
Well, if their position was we would have signed the checks and sent them to the contractor, then we would have a further breach of contract claim against them because at the point in time no repairs had been made. So you're
saying that's not U.S. Bank's position in this litigation?
Well, that might be what they've stated as their position, but that's not what should have happened. So in other words, the fact that U.S. Bank in these proceedings has said we don't have any interest at all in these funds, and we would have just turned them over to the contractor if that's what they're saying, that would have not been something that the mortgage insurance clause would have allowed them to do.
But in this sense, the claims against U.S. Bank the facts of that claim merge with the facts of the conversion claim or the allegations of the conversion claim, in that it seems to me that perhaps the better reading of the mortgage insurance clause is not that that U.S. Bank was obligated to oversee construction, but that it had the right to, if it cared to.
Well, but the borrowers still have rights in that clause, and one of the rights is the is the right to have the funds applied to the mortgage itself. There's a case that's the closest case on point, I think, is the Schoolcraft case out of California, where the funds were received by the mortgage company, and then they were, I believe if I recall the facts of that correctly, the funds were not applied to repair, and that was, even though they had the mortgage company had the right to make a decision in that clause about how to apply the funds, they exercised their discretion in a way that deprived the borrower of their reasonable expectation of the bargain. So in this particular case, if U.S. Bank's intention had been to sign the check, they would have returned it to the plaintiffs. They wouldn't have given it to the contractor.
And then what would have happened?
If the money had gone to the plaintiffs, then they would have retained that money, because that particular contractor had not done any work. He didn't have any rights to any of the funds. So in this particular instance, if the money wasn't going to be used to reduce the amount of the mortgage, then it would have just been the plaintiffs would have had that money to reimburse themselves for the out-of-pocket expenses they incurred in making the repairs to their home. So they were shorted $90,000 out of their insurance payments, and they had to make up that money by borrowing it from other people, and from skimping a little bit on what they did for their repairs. One of the principal contentions, and one last point on the UCC issue, the defendants make the point that because my clients signed the back of the check, they signed the back of the check in order to facilitate its deposit at US Bank, that act has deprived them of their rights to the check. And if they, at the same time, they cite to the comments for UCC 3-420, and further in the comments, it indicates that there's an example. It's on my copy. It's the second of 3 pages. Gives an example of a check that's payable to the order of A. A endorses it to B and puts it in an envelope addressed to B. The envelope was never delivered to B. Rather, thief steals the envelope, forges B's endorsement on the check, and obtains payment. Because the check was never delivered to B, the endorsee B has no cause of action for conversion, but A does have such an action. So in other words, even in the comments to the conversion UCC provision, signing the check does not deprive the party of their rights under the UCC. And that's and again, we go back to what the statute actually says. It says it's an act that accompanies giving the instrument to someone for the purpose of enforcing it. And there was no right to enforce it because it had not been endorsed, because it's only endorsed when all of the payees have signed it. It would be a different case if U.S. Bank was first and if my clients were second to last, and that the contractor received the check with the endorsement of all of the other payees. But that's not what happened, and that's not what happens in these cases. And so as it relates to our breach of covenant of good faith and fair dealing claim, the right that my clients had in the funds was an expectation that they would either go to repairs or go to reduce the amount of their indebtedness. And the case law rejects the contention that that's made without any support, that this clause only is to the benefit of the mortgage company. The borrower benefits.
But there's no allegation that U.S. Bank ever saw the check. So how can it be liable for not having done something with the check?
Well, it's still this is one of the errors of law below was the conclusion that U.S. Bank had no rights at all, and that's not correct. They had a right to enforce the checks, and so in other words, U.S. and it's conceded to in the briefing from the defendants on pages.
Well, I think the Superior Court says that if somebody has a claim, it's U.S. Bank. The Superior Court seemed to recognize that U.S. Bank would have a claim from the fact that the check had been cashed without its signature.
Well, but the mistake, though, that the trial court made was saying that there was nothing that it could have assigned, and the right to enforce the checks could have been assigned by U.S. Bank. And
The complaint doesn't allege that your clients asked for an assignment, does it?
Yeah, it does actually. Our complaint, our second amended complaint alleges that the breach of the contract and if there's no breach of contract, that the act of that's the breach of the covenant of good faith and fair dealing was either self-dealing with, well, it was refusing to assign the claim, or in the arguments below and in the briefing below, we indicated that one act that could have been one thing that could have happened is that that right was assigned or somehow transferred to the other banks in this case. And we don't know what happened, but if in fact, and this was our argument in the oral argument back in February of 2014, was that if what happened was U.S. Bank had somehow assigned the rights to Chase and Wells Fargo, that's an act that is a breach of the covenant of good faith and fair dealing, because it's that act which deprives the plaintiffs, the borrowers, of their right to have that money either go to repair or go to reduce the indebtedness.
I'm not sure the complaint alleges an assignment, though. And I'm not sure the complaint alleges that your clients asked for an assignment, and I'm not sure it alleges that U.S. Bank nevertheless assigned it to someone else.
Well, we didn't know that at the time. You know, with respect to the allegations in the complaint itself, we had argued that we had alleged. I'm sorry. This is on page 77 of the appendix. Plaintiff's rights to the.
What paragraph of the complaint?
This is the very bottom of paragraph 12.
Okay.
That's that Chase and Wells Fargo engaged in concerted action to make unnecessary demands to aid the third party, the contractor, and then on more specifically to U.S. Bank on page 7, that U.S. Bank failed to either assign its rights to enforce the checks to plaintiffs or seek enforcement of its rights. And that's on page 79 of the appendix. It's paragraph 22.
Okay. Thank you.
And it's clear in the briefing in our argument that we had raised this as a possibility. We didn't have a more clear basis that in fact there was a meeting until some documents came out in discovery. I'll reserve my 3 minutes and change to rebuttal.
Thank you.
Here is Mike Platty, law firm of Dickinson Wright, here on behalf of J.P. Morgan Chase Bank and Wells Fargo Bank. The essence of the case, which
Are you expecting to take up all 20 minutes, or are you going to divide?
No, we're going to split our time.
How much?
10 minutes.
Okay.
It
So we
might
know.
be less.
That helps us understand.
Yeah, and it might be less. The essence of the case, I believe, as you've gathered, is that you've got a situation with a multi-payee check, and plaintiffs are one party, the contractors are another party, and the mortgage lender is the third party. And the check is to repair water damage to their home. The plaintiffs, I think it's clear, endorse and deliver the checks to the contractor. The contractors went straight to Chase Bank, which was the contractor's bank, presented for payment, and Chase paid that, even though the bank, US Bank, as the lender, hadn't endorsed the check. And the question here is, okay, who's got the beef? I mean, who's got the beef with Chase for doing that? There's no question that under 3110D, the endorsement of the lender was required, sure. But who's got the beef with Chase for that?
What's a case that decides that for us?
Yeah, we looked. We haven't found one that's on point. I mean, that's true. That's true.
Wouldn't you think?
And why wouldn't the check go into an escrow account? Let's say the check is $200,000 and this particular contractor is going to do $20,000 worth of work. Why wouldn't the assumption be that it's going to go to pay the mortgage, but doesn't that benefit the homeowner in that circumstance?
Right, but in that instance, if that was the case, the lender would make the claim, and it would be that the plaintiffs would benefit from that claim. But once that endorsement and transfer happens, okay, as far as the instrument, we're just talking about their rights to enforce the instrument and have an interest in the instrument.
So you
that gets
disagree with
transferred.
the analysis that the statute, that under the relevant statutes, no transfer occurred,
Correct.
would not have occurred until all
No.
the payees endorsed?
Correct. There was a transfer. There was a transfer of the interest of the party that was transferring.
How could they transfer their interest prior to the endorsement? I mean, when there's a multi-party negotiable instrument, don't all have to endorse them? Doesn't it need to be negotiated before there can be a transfer, an effective transfer?
No, that's not what the statute says. 3203B indicates that the transferor's interest, all rights vested, become vested, and those interests are transferred under 3203B, if I can just find that right there. What they're trying to say is that, no, that transfer can't happen unless the entire interest is transferred, and that's not what the statute says.
I guess what Mr. Silverman, though, is saying, he's looking to subpart A of the same statute, 3203A, which says that a transfer happens when a person delivers a check for the purpose of giving to the person receiving delivered the right to enforce the instrument, which kind of raises the question of intent. What's the intent of appellants here in giving it to the contractor?
Correct, but so you have the endorsement statute talks about how when you have an endorsement, the presumption is that's an endorsement unless there's unambiguous indicia that is not. So under that statute, yes, they deliver that for the purpose of enforcing the right, and then B gives you what that says is that all of the rights of the plaintiffs are now transferred to that person it's delivered to. So it's the endorsement and the delivery.
If it's delivered for the purpose of allowing the person to enforce it, and I guess they're saying no.
Yeah, but it is. It is because that's what the contractor is going to go do with it. And now the fact that
How do we know that the contractor is not going to deliver it to US Bank for it to be put into an escrow account?
okay, and if they did that, okay.
But
That's
wouldn't that
okay.
be a more reasonable interpretation of the intent of the plaintiffs or the appellants, given that there was a third payee? The more reasonable inference would be that they intended the instrument to be negotiated as written, as opposed to.
I would disagree. The most reasonable inference would be that when they endorse the check and deliver it to the contractor, they're saying, "Hey, contractor, you got our interest now." Okay. If they wanted to do what you were talking about with the bank, I mean, what they could have done was just say, "Okay, contractor, you endorse this, and I'll take it over to the bank," if that was what their intent was. Okay. The statute, basically, the way the statutory scheme is set up is that you endorse and deliver. You're saying, take what I've got. You've got what I got right now. And I do not disagree that bank makes a mistake. Okay. The lender doesn't endorse there. But that means the lender would have the claim against us. And they've explained why they're not making a claim against us, is that because the money went where it was supposed to go and everything happened like it was supposed to happen. Kind of goes to the causation element that Judge Catani was talking
Causation
about.
required for a conversion claim? The UCC statutory conversion?
Well, under UCC, yes, it would be. It would be. And
Do you have a citation for me on that case or part of the UCC or an Arizona statute that tells me that causation is an element at this very early 12B6 stage is just a pleading requirement?
it's wrapped up in that language that says you don't have a conversion claim if you don't have an interest in the check. Okay, so once they give over everything, okay.
So if we disagree with you on the transfer, that's sort of the ballgame they've pled is sufficient conversion claim.
If you disagree on the transfer, I think there's still a causation element because I think since US Bank is saying here, hey, this happened the way it was supposed to happen.
But what's
what we
the
would have done.
authority for requiring a causation element outside of you pointed to the transfer. If I say I disagree with you on that, what else tells me that there is a causation element in the pleading requirements?
Only the language in the statute would tell you that.
What statute?
3420.
Okay.
3420 requires, there's language in it that requires that there be an interest in the instrument for you to have a conversion claim.
But again, if I disagree with you that they
Right.
transfer their interest, so that's it. That's where the causation element is found.
I believe that would be the case. Yeah.
And
I
you're
believe-
saying there's no interest if I'm the homeowner and I'm expecting that this check is going to be deposited to pay down my mortgage, but I don't have an interest in the check after having signed off on it, regardless where it goes.
Correct. You would have you've given all your rights over your right to enforce the instrument. We're just talking about the instrument now. Your rights to enforce the instrument, your rights to have an interest in the instrument are given over as soon as you endorse and deliver that. Okay. Now you may have a claim. You obviously have a claim against a contractor if he doesn't do the work. May have some other kind of claim against US Bank under the contract. I don't know, but with respect to us, you endorse that. You don't have that claim. Okay, the beef is with the only party that would have a beef with US Bank with my client, Chase, would be US Bank. They would be the ones that would say, hey, wait a minute, you negotiated this. I didn't endorse it.
So
They're the
US
ones that
Bank
have the claim.
could have brought the conversion claim.
Conceivably, they could have, but they've explained why they didn't, because that's not what was supposed to happen here. Okay, and I'll let them speak more to their position, but their position was basically, oh, this is the way it was going to happen. We would have signed off on this. They had no problem with the repairs. So that goes to causation as well. I
I think the
believe.
repairs had not taken place yet.
But the repairs were ultimately done, and that's why US Bank signed off on is not making a claim against us because they're happy.
Said they would have signed off.
Correct. And that goes to causation. So in that sense, causation is a sort of a separate element. There's no damage here from anything. There's no damages from any conversion. If US Bank would have done exactly the same thing how it ended up here, they would have just signed off and everybody would have been happy. Unless there's any other further questions, I'll leave the rest to my co-appellee.
Thank you.
Good morning, Your Honors. May it please the Court, I'm Sarah Ankers on behalf of Defendant US Bank National Association. The Court properly dismissed the second amended complaint against US Bank pursuant to Rule 12b-6. And because we're on a Rule 12b-6 motion here, that's where this appeal is, the complaint has key admissions that dispose of the claims against US Bank. Those key admissions are the allegations that US Bank never received the checks, never signed the checks, never received the proceeds from the checks. And so appellants claim that they should receive the insurance proceeds, that US Bank should pay the $90,000 to them, or should assign them a claim, or should pursue Wells and Chase for $90,000. But the second complaint simply does not allege facts to support any such claim for relief against US Bank. I wanted to address the breach of contract claim first, since that seems to be the one that the Court was concerned about and that Mr. Silverman has spoken about. There's no allegation in the second amended complaint of any contractual obligation that US Bank had to assign checks to, or assign a cause of action for the checks to the appellants.
I think the argument is that that's implied in the covenant of good faith and fair dealing under these circumstances.
Pardon me. And to take that point, to just look at the Section 5 of the Deed of Trust, this mortgage insurance provision, the language of that provision puts certain obligations on the borrower. It starts off that in the event of a loss, as we had here, a flood, that the borrower must give prompt notice to the insurance carrier and to the lender. There's no allegations that such prompt notice were given to US Bank as the lender. And then it gives US Bank the option. It can hold those proceeds and can do the process where it holds the proceeds and disperses them and then has a final inspection and disperses the funds. But that provision certainly does not obligate U.S. Bank to do so. And in reading the provision in the context of a deed of trust, which is to secure the loan to protect the bank's investment here when it's made a loan, that provision is for U.S. Bank's benefit in terms of it is for U.S. Bank to make sure that its collateral has been properly repaired or restored, or if that wasn't possible, that there is money to pay down the loan.
You know, accepting that to be true, wouldn't given that it seems to everyone that U.S. Bank could have sued Chase for conversion, Chase and Wells, if it had cared to, isn't the obligation to assign that claim to the borrowers, to the appellants here, part of the bank's implied covenant of good faith and fair dealing under the deed of trust?
Your Honor, I do not see that there can be a reasonable reading of the deed of trust that U.S. Bank has an obligation to go out and get insurance proceeds.
Well, I'm not saying that. I'm saying assign the claim. I tend to agree with you that U.S. Bank isn't obligated under the deed of trust to pursue the matter or to oversee the construction. But here, when the plaintiffs, arguably, or SOL, and U.S. Bank has a claim, it could raise. Doesn't U.S. Bank have an obligation under the implied covenant to say, here, take it?
Your Honor, I don't believe that they have such an obligation in terms of U.S. Bank doesn't have an obligation to give certain rights that it has to a borrower, or that U.S. Bank has an obligation to let a borrower sue in U.S. Bank's name.
But what if the check had been for the hypothetical I gave earlier? It's a $500,000 check. There's a contractor that's going to do $50,000 worth of repairs. Wouldn't U.S. Bank have an obligation to ensure that if the check was cashed and $500,000 was given to the contractor rather than $50,000, doesn't U.S. Bank have some responsibility to the homeowner in terms of U.S. Bank had a claim for conversion that the money should not have been given to the contractor? Why wouldn't that claim rightly go to the homeowner? If that makes any sense.
So Your Honor, as I understand from your hypothetical, there's a check that's made payable to the homeowner and to the contractor and to U.S. Bank for
Right.
$500,000. The work that needs to be done for some reason is only $50,000, and so U.S. Bank actually gets those proceeds.
Well, why wouldn't those proceeds be used to pay down a mortgage or something that would benefit the homeowner?
Well, certainly if U.S. Bank had received proceeds, then proceeds, and if it had chosen to hold those proceeds and pay them, then it could have overseen, not overseen the construction, but done its process of dispersing and then inspection and disperse the
Do you agree
funds
that
to the
US
contractor.
Bank, would U.S. Bank have a conversion claim against Chase under that?
If that 500, I'm sorry.
Yeah, the $500,000 went to the contractor.
If the $500,000 went directly to the contractor and U.S. Bank had never received the check,
Right.
had no knowledge of the check, didn't
Right.
sign the check.
Right. Why would you not have a conversion claim if the check was intended to go to you? It ended up in the hands of the contractor, being cashed by the contractor.
Well, Your Honor, I think the difference here is that it's not as if these funds were to necessarily go to U.S. Bank, right? I mean, it's $500,000 that is to be, a certain amount is to go to the repairs of the property, and then the remainder, if it only is costing the homeowner $50,000 to repair the property, then the homeowner may have the remainder. Is that what you're asking?
Well, I guess I tend to agree that if all of the evidence comes out after discovery that that U.S. Bank was perfectly willing to sign over check and the amount that was tendered, that the plaintiff is not going to win anything. But in terms of just at the pleading stage, just trying to figure out if there is a scenario under which this is at least a legitimate claim that survives a motion to dismiss.
So if you go back to the deed of trust, it says that if the restoration or the repair is not economically feasible or lender's security would not be lessened. So if there's not going to be, it sounds like there's only $50,000 worth of damage here, that the security is not to be, its security interest is not going to be lessened, then the excess proceeds would be paid to the borrower under the deed of trust provision.
Something that has to be determined through discovery and resolved?
Well, I don't believe so, Your Honor, because here we don't have a situation where U.S. Bank actually received any of the proceeds, and so the process here in terms of whether or not it's economically feasible or security's interest would be lessened, that didn't come into play because the proceeds were never given to U.S. Bank. And so they were never deposited with U.S. Bank, and so that whole procedure didn't go forward. And in terms of if U.S. Bank had been given that check, it could have, under this provision, and under its good faith obligations under this provision, it could have signed that check, and that check would have gone to the contractor, or the appellants say that they should have received that money. It's between the appellants and the contractor at that point as to who receives that money.
But you would agree that U.S. Bank's the entity in the room that has a conversion claim.
Potentially, except that U.S. Bank doesn't believe that it's been damaged.
Okay,
here.
well that's I guess that's a different matter.
Right.
Why if it has a conversion claim, why isn't it not obligated under the covenant of good faith and fair dealing to give that claim to the appellant so they can sue?
Your Honor, because it doesn't want to make an illusory assignment, and U.S. Bank here does not believe that it has a conversion claim because there's no allegation in the second amended complaint as is reflected in the actual facts as I know them to be, that U.S. Bank was satisfied with the condition of its collateral. There's no liens, subcontractor liens, mechanics liens against the property. There's no, so that U.S. Bank has not been damaged, and so would not have a conversion claim. If appellants believe they have a conversion claim, then that claim's personal to them, and not something that U.S. Bank could have taken. In terms of the two cases that I only have a few minutes left. In terms of the two cases, Gillis and Schoolcraft. Pardon me?
I'm sorry. Your time is about up.
Yep. Thank you very much, Your Honor.
Thanks.
A lot of the arguments made by the appellees are essentially fact questions that aren't appropriate for 12b6 resolution. The counsel for Chase and Wells Fargo, I think, made an admission that supports 100% our breach of the covenant of good faith and fair dealing claim. The lender would make the claim. The plaintiffs would benefit. And that's kind of the essence of what our breach of the covenant of good faith and fair dealing claim is, that we would have benefited from the reasonable and expected exercise of discretion on the part of U.S. Bank. Because if what happened here is that U.S. Bank instead sold the rights in some fashion to Chase or Wells Fargo, that's clearly a breach of the covenant of good faith and fair dealing. And those are facts that are
How are you suggesting that it sold rights to Chase?
Well, I was just saying those are facts that again, this is at the pleading stage.
Well,
so
you can't just make up stuff.
well, we know.
Have you got any reason to think that happened?
Well, we learned in the course of the briefing that there was a meeting between U.S. Bank and Chase and Wells Fargo at a point in time in which I was trying to engage U.S. Bank in discussions to, they were only brought in as a very last resort. And even when they were brought in, we submitted a $1 offer of judgment to them with an assignment. So we learned that they met. If we're looking for an explanation as to what occurred, that's a possible explanation. And that would be something that, if it occurred, and it's something that the 12b6 standard is that if there's any interpretation of the facts susceptible to proof, then the 12b6 motion is not appropriate. This would have been very easy for U.S. Bank to avoid at any stage of this process. And so what's our basis? Part of our basic.
What are you saying they should have done? At what stage of the process?
Before they were joined in the case, I made attempts to contact U.S. Bank, and then I talked to U.S. Bank's counsel before proceeding with.
But if their position was we would have just signed off on that check and it would have gone to the contractor, what would you expect them to do? But that's not
factually correct. That's not what the facts in this case show. The contractor had not done any work. He wasn't entitled to any of that money. The only reason that the security wasn't impaired was because my clients.
People paid sometimes before work starts.
Not in this particular instance. Just the work had not been done. They had not. I think they might have fired him later, but he didn't have a right to the money. The only reason we're in this position is because my clients acted in good faith. They continued to pay their mortgage. Had they not done so,
but I guess my question is if this goes back and there's a trial and U.S. Bank comes in and says all we would have done was sign the check and it would have gone to the contractor, whether that's to pay for materials ahead of time, that's what we were going to do. What's your claim against Chase?
Well, first of all, factually we contest that. We don't think the facts will show that. But our claim against Chase is we still had that right to have those funds. This wasn't the $90,000 was money that my clients had to come up with separately. They didn't have the money, and I see that I'm out of time. So
okay, thank you. Thank you to all the lawyers for your briefing and your argument. We'll take the matter under advisement and issue a decision in due course. And now we'll recess for just a bit to allow the next case to set up.